So I get to work with a lot of also very creative people, lawyers. And I get to share the panel today with a superstar setup of lawyers that I'm going to let them introduce themselves right now, starting with Judy.
Hi, everyone. I'm delighted to be here. I'm Judy Rynearson. I'm a partner at K&L Gates, and I specialize in emerging payments. And I was one of the lawyers who had the honor and experience of participating in the testimony before Losky when he decided to start regulating here in New York. I apologize. It was not my fault. But it is becoming a more and more regulated area, and I'm happy to be here.
Hey everyone, Mike Selig. I am an attorney at Perkins Coie in the New York office here. I've been in crypto since around 2013. I was at the Commodity Futures Trading Commission in Chairman John Carlo's office when we first started kind of looking at these issues and considering whether Bitcoin at the time was a commodity, and that was always a fascinating topic that kind of drew me into the space. And ever since I've been working both in the public and private sector, focused on crypto and commodities laws, securities laws, and money transmission laws.
My name is Felix Shipkevich. I'm an attorney based in New York City, specializing in payments and commodities law. I've been in the crypto space since about 2010, when I was actually in-house at a futures commissioned merchant, which is a broker-dealer on the futures side. I do a lot of work with crypto exchanges and helping them navigate the very complex money transmission regulatory environment. In addition to practicing, I spend half of my time actually teaching law at Hofstra Law School, where I teach corporate finance and a course on cryptocurrency regulation. Thank you.
Hi, my name is Mary O'Hara. I'm a corporate and securities lawyer here in New York. I work with MG Plus, also known as Missouri Griffiths. We represent companies in the blockchain and crypto space on a fairly regular basis. We're a small transactional firm, small, nimble, independent transactional firm, and we represent companies in the space. My background is in corporate and securities law, so I think that's what I bring to the panel in the analysis of whether or not a particular token is treated as a security. I think is the key issue that I'll be focusing on.
Hi, my name. Whoa, hey, everyone, wake up. My name is Brian Klein. I'm a litigator. I'm based in Los Angeles. I represent a lot of people and companies in the space, blockchain. I have people who launched Zcash, the Brightmans behind Tezos. I was here for a hearing. I represent Charlie Shrem. I have a lot of cases in front of the SEC, the Department of Justice, and the CFTC. And I don't give advice. I like to say I don't give opinions, I defend them.
Well, thank you all for being here. As a CTO, I have been watching a lot of the presentations throughout the day, and they've been getting me really giddy and really excited about coming out with my computer and building some new things. And I'm sure a lot of people share that sentiment. And that's also, I think, something that gets some of us in trouble in this space. So what better opportunity to kind of go around and get a really qualified perspective on what are some of the things that we need to know or we need to do as we build these projects to keep ourselves out of trouble. Judy, do you want to start? You have a few slides.
I'm the only one here with some slides. It's a lawyer's crutch. I think I'm supposed to turn it there. And this is what I wanted to talk about. Where do NFT fit, and how to avoid having your NFT become either a security or cryptocurrency. In particular, I'm looking at the crypto side, all the New York bit license laws, the FinCEN and their AML requirements, and it's just important. I know it sounds a little boring, but it's important just to know what the law says. And so this is the law. This is the definition of virtual currency under the New York bit license law. You do not want to cross this line and get into this space, trust me. So a virtual currency, medium exchange, it substitutes in a transaction for money, but it's not money. It can be either centralized or it can be not centralized. And the important part is What is not? It's a wonderful thing about the law. You have the rule, and then you have your exclusions and exemptions. So they have three major exemptions. Digital units used solely with online gaming that can't be converted into fiat or virtual currency. Digital units that can be redeemed for goods, services, discounts, but as part of a rewards program. And that's a really important, or customer affinity group. So that's a really important exclusion. And then finally, digital units used as part of prepaid cards. So if you're working with a prepaid card issuer, you've got points, tokens, whatever you're using, that helps you get away from having to be licensed as a cryptocurrency issuer or exchanger or business. So this is the last FAQ that I thought would be interesting for those of you in this space. Is a BIT license required in order to engage in non-financial uses of virtual currency? And the answer is actually no. Where it is undertaken for non-financial purposes and does not involve more than a nominal amount of virtual currency, then you don't need a BIT license. A lot of the things you've been seeing are very small dollar amounts. It might fit. What is a nominal amount? Of course, that's always something you get the lawyers together and they'll argue that. So I want to thank Jeremy and Dan. They're my two associates who love this area and wish they were here. So I know my colleagues have other thoughts.
Thank you. Mike, how do we stay out of trouble?
Well, I guess the big question is, outside of kind of the BIT license and these state regulations with respect to money transmission, you're dealing with three major federal regulators. You have the Commodity Futures Trading Commission, the Securities and Exchange Commission, and FinCEN, which is a branch of the Treasury. And each of them regulates somewhat overlapping domains. You have the Securities and Exchange Commission that's looking at whether these products are securities. The Commodity Futures Trading Commission looks at really whether they're products that are traded as derivative instruments, as well as, you know, the underlying commodity that those futures and swap products can be traded on. So you're looking at a anti-fraud regime with respect to the spot market. So just trading a non-fungible token can result in regulation by the CFTC if there's a feasible concept of a futures contract or swap contract that can be built on that product. And then you have FinCEN, which looks at, similar to the money transmission regulations at the state level, whether these are used for purposes of money transmission. And when you have a non-fungible token, although it's not intended to be a currency per se, can you move funds with it? Is there a reason that the Treasury is going to be concerned that you could potentially move money offshore or illegally through a CryptoKitty, for example? And I should add to that OFAC, which is looking at sanctions. So you do have kind of four regulators that are going to be very involved at the federal level, and in order to stay out of trouble, you have to consider, A, what's your product? Is there a potential that it could qualify as a form of funds transfer? With respect to money transmission, it's going to be a commodity pretty much no matter what. And then, is it a security, which would kind of take it out of the commodities world, potentially out of the money transmission world, and you'd be looking at the securities regulations and laws, which are pretty difficult to comply with.
Thanks, Mike. First of all, great job. 7 p.m. You're listening to 5 lawyers speak. I don't know if I'd be around here at 7 p.m., but thank you for your time.
Yeah, we had to restrain you from
highlight.
leaving.
Yeah, that's right. Give him an applause.
So, look, each of us has about 3 minutes, so there's really not much that I personally want to tell you. I'm sorry to disappoint you in those 3 minutes. I think that what I usually, what I do is I try to dissect whether or not your token is a payment instrument or not. That usually is my first test. If it's not a payment instrument, if it's an asset-based token, talk to securities lawyers. That's a good starting point. If it's anything payment-related, and the payment-related doesn't necessarily mean it could be convertible or not convertible, whether it's a reward token, then you need to probably speak to one of 3 of us, because this is what we do for a living. I think the biggest mistake that people make in this space is they don't start from the high picture. They immediately either say, well, my token has nothing to do with the SEC, so screw you, I'm not wasting my money on lawyers. Or, oh, I have to look at money transmission statutes. What does it have anything to do with crypto? And the reality is that majority of the states, about 30 states, will require you to become a money transmitter if you have a convertible token or payment token. There are states that have taken the position, like for instance, the state of Pennsylvania a couple of weeks ago came out with what I consider to be a pretty bizarre notice many years after companies like Coinbase have spent a ton of money becoming compliant in Pennsylvania to say, well, we don't regulate crypto. So start at the top, start asking yourself questions, dissect, let somebody who actually knows what they're talking about help you. Otherwise, you can get into a lot of trouble, and hopefully you don't. Thanks.
So I'm going to start by saying something that might sound a bit controversial on the panel, and that is I do believe that NFTs are the one area among tokens where you can make the strongest arguments that they are not securities for several reasons. I would say that with two very strong caveats. One is you should always, the test of whether or not a token is a security is very facts and circumstances specific, and this area of law is fluctuating, it's being developed. The SEC is getting their arms around this still as these new applications come up. So you do need to consult with a lawyer before you issue tokens of any kind and get an analysis as to whether or not it's a security. And if it's on the fence, you need to try to at least, with respect to the issuance round, comply with the securities laws. I do think that NFTs are the least likely to be regulated by the SEC, partly because of their non-fungibility. We think of securities, we think of a fungible asset. For example, a share of common stock in a corporation looks like every other share of common stock in that corporation. So fungibility tends to be a hallmark of a security, and if something's non-fungible, it doesn't look as much like a security. But delving into the essence of a non-fungible token, you can look at the types of applications and the circumstances surrounding their issuance and their use. And that's where you really get into the meat of the analysis of whether something's a security. You get into something called the now pretty famous Howey test. Show of hands, how many people have heard of Howey or familiar with it? I think many more than would have 5 years ago. It's become pretty widely known. But for those who don't know, it's a test to determine whether or not an asset's a security. You can run it down in 4 factors. An investment of value in a common enterprise with an expectation of profit based on or derived from the endeavors of others. So this test results in many tokens being deemed securities by the SEC, and they're most likely correct about that in those contexts. But in NFTs, you frequently have applications where you fail. It's a test. First of all, you want to fail the test. It's a rare test that you want to fail. If you fail one prong of the test, you're not a security. So that's good news. I think that NFTs, for example, in ticketing, in gaming and digital collectibles, in certification of assets in the physical world, you get into some nice fact patterns, and we were actually discussing them backstage, where it's kind of close to the line, and there's some interesting sort of intellectual conversations about whether or not it's a security. And once again, if there's any doubt, you should consider complying with the securities regulations in your issuance of tokens. But I do think a very strong argument can be made in each of those areas against it being a security. And one final caveat that I would give, is I think I'm running out of time. I could talk about this for hours, but is that if you're doing a pre-sale round, and apparently a lot of the panels and a lot of people in the conference have been discussing pre-sale rounds of tokens. Anytime you're taking money in with people who expect to profit from a platform that's not yet developed, from the development of the platform, they expect the value of that token to increase once the platform is set up. That is very likely a security. I suppose somebody could present a fact pattern to me and make an argument that it's not for some reason that I'm not considering right now, but almost certainly that's a security because it's the endeavors of others, it's an investment of value, common enterprise, et cetera. So that's probably going to fail the Howey test. If you're talking about pre-sale rounds or anything where you're taking investments to develop a platform that's not yet developed.
So I'll jump in. I mean, I disagree with that, but I don't give advice, I defend it. I think two things. One, don't be afraid to innovate. Two, go talk to a lawyer. And I'm not the lawyer you would talk to, so it's not even a self-serving thing to say. Because people come to me when it's too late. They've gotten a subpoena, they're being sued, or they want to sue somebody, right? You don't want to be in those positions. Now, I'll tell you right now, despite your best efforts, you still may get a subpoena, because I have a lot of clients like that too, whether from one of these alphabet soup agencies. But I think big picture, you can't be afraid to innovate, and you should talk to a lawyer. I think right now the federal government, a number of these agencies are drawing as super broad, ridiculously broad nets, because of course they look around and say, hey, I'm the SEC, I'm the CFTC. Everything but onions is a commodity, and I'm the SEC. Everything should probably be a security. And I want to have, sort of regulatory capture, right? They want to capture the biggest thing to justify what they're doing. Not that they're not all not trying to operate in good faith, I'm not saying that, but there's a lot of these battles are to be fought, but in the meantime, you shouldn't be afraid to innovate. And I think this space is really interesting, and this outgrowth of NFTs is fascinating. And I think there will be a lot of things to happen. Now, right now, they're not worth a lot of money, so people aren't really paying attention. That doesn't mean you shouldn't go to lawyers, because at one point when I got involved in Bitcoin, and others here were involved very early on, Bitcoins weren't worth anything, and really no one was paying attention. But once things start to rise in value, once the businesses build out, guess who starts paying attention? The federal government, the state governments, other parties, and that's what you've seen in the last couple of years. Litigation was not really happening, but in the last couple of years it's gone crazy, frankly. And so that would be my 2 cents.
If I can ask a quick question, I am curious just to clarify for the benefit of the audience, which aspect of what I said you disagree with?
Well, I think that there is the Howey test, but I think it's grossly over-applied. And I think there are a lot of things that have either utility or aren't meant to be captured by the Howey test. The Supreme Court, when it came out with it, wasn't saying, guess what, this is the broadest test ever. Like, what does it mean by the efforts of other? The definition says solely the efforts of other. But courts have expanded that to say, well, derive mostly from the efforts of others. And so the SEC doesn't even recognize one of the prongs. They don't think one of the prongs of the 3 or the 4 are even there. So there's a real battle over it, and I think those things are going to be decided in courts. Now, does the SEC always wrong about what qualifies? Of course not. But are there areas where they are taking an aggressive position? Yes, because they're worried about, and probably from their view, understandably so, that if they don't take a position, that the whole market will drive through that hole that they create.
I wouldn't disagree with that. I think that
There
kind
we
of
go.
illustrates.
We solved the problem.
But I think that illustrates the difference in thinking between a litigator and somebody who's, pre-strategizing deals. We tend to be a little more conservative, and you're more in an advocacy
Yes,
posture.
people come to me and they said, this is what I did.
Right.
How do you help me get out of this situation?
And we try to
I
avoid
spend
that
a lot
scenario.
of time doing that and hopefully coming up with good arguments. And I'll say early on, there was a lot of misunderstanding in this space, and I had a lot of clients I was able to go in and meet with regulators or law enforcement and talk them out of things because they didn't even understand what the product was or what was happening. Yeah. And I suspect that will be very prevalent in this space, that a lot of regulators and law enforcement will have no effing idea what an NFT is.
Great.
And it will totally confuse them.
Well, I love that encouragement to innovate. You heard that from a lawyer, so that must be what we need to do. That's
Responsibly.
all.
Just be careful about telling everyone what a great investment your token is.
Mm-hmm.
Those kinds of things can come back and haunt you. Be careful what you say.
So that's all the time we have, but thank you guys. Can you give a round of applause for this great panel?